Welcome, everyone, to Washington Legal Foundation's webinar. Thank you for joining us today. My name is Glenn Lammy. I am Executive Director and Vice President for Legal Studies at the Foundation. Those of you not familiar with the Foundation, we are in our 48th year of public interest law advocacy, education, and litigation. If you are interested in learning more about the breadth of what we do at the Foundation, you can go to WLF.org. We do about 20 programs like this a year. We file briefs in the U.S. Supreme Court and the lower federal courts and state courts as well. And we put out quite a few publications per year, some of them written by our speakers today. And we also have a blog called the WLF Legal Pulse. So I'm going to introduce our guest moderator today. It's Mark Behrens, who's co-chair of the Shook Hardy and Bacon, Washington, D.C.-based public policy practice group. He's also a leading national litigator on civil justice issues. A essential part of his practice is working to improve the civil litigation environment through legislation, in the courts through amicus curiae briefs, through legal scholarship and judicial education, and in the court of public opinion. He authored a law review article this year for the Cornell Journal of Law and Public Policy on third-party litigation funding, which I've put a link to in the chat. Mark chairs the International Association of Defense Counsel's Civil Justice Response Committee, serves on the board of the directors of the Lawyers for Civil Justice, and most pertinently to us, serves on Washington Legal Foundation's Voluntary Legal Policy Advisory Board. I'll note that this program is being recorded. If you have questions for our speakers, please use the Q&A function at the bottom in the toolbar and type your questions up, and then Mark will provide them to the speakers. Without further ado, I will hand it over to you, Mark.
Thank you, Glenn, and thank you to Washington Legal Foundation for hosting this event today. I'm excited about the topic and to hear from our speakers. In its 2015 annual report, one of the leading global litigation financiers, Burford Capital, explained that a litigation claim is an asset. It may seem strange to think of litigation in that way, but if one strips away the drama and the collateral dynamics associated with the litigation process, a litigation claim is nothing more than an effort to get money to change hands. 10 years later, scores of other investors have joined Burford in seeing litigation as a lucrative investment opportunity. Global litigation funding investments are estimated to reach nearly $19 billion this year and may exceed $67 billion by 2037. In addition to third-party financing of mass actions, mass torts, third-party funders are selling their services for business-to-business litigation and even business defendants in mass or class litigation. Obtaining third-party litigation funding, as well as having to defend against a claim supported by funding, is giving rise to a growing number of ethical, regulatory, and legal questions. States are beginning to pay attention to calls for disclosure, as is the federal judiciary, which has created a third-party litigation funding subcommittee as part of its advisory committee on civil rules. We're pleased to have with us today three attorneys who will delve into the many legal, ethical, and regulatory issues surrounding third-party litigation funding. They have a lot of ground to cover, so let me quickly introduce them. Erika Zolner is a partner in the Chicago office of Redgrave, L.L.P, and also serves on the firm's executive committee. She provides proactive and strategic legal counsel in eDiscovery and information law matters, including advising clients on the development and execution of defensible eDiscovery processes. Prior to joining Redgrave, she was with Kirkland & Ellis for 20 years. Our other panelist, Casey Fronk, is of counsel to Redgrave, practicing in its Chicago office. He has extensive experience handling complex litigation, investigation, and regulatory matters. Prior to joining Redgrave, Casey was a senior trial attorney at the SEC, a partner with Kirkland & Ellis, and a law clerk on the Ninth Circuit to Judge J. Bybee. Our third panelist, Emma Hall, is counsel to Redgrave LLP, practicing in the firm's D.C. office. She has extensive experience representing Fortune 500 companies in complex litigation and advises on developing and implementing comprehensive discovery strategies in litigation matters. Prior to joining Redgrave, she was an associate with Morgan, Lewis, and Bacchius. I want to welcome the panel and thank everybody for being here.
Thanks so much, Mark. Hi, everybody. So we're going to start with just some key concepts. What is third-party litigation funding? So there's kind of a spectrum of third-party litigation funding arrangements. And the ABA report, which we'll talk about later, kind of puts them into two basic categories. There's the more traditional and well accepted forms, which would include funding that provides living support for unsophisticated litigants, and then cause-based funding. So those are the sort of types that have been around for quite a while and are a little bit less controversial or polarizing. And then more recently, we've seen the rise of commercial litigation financing, and specifically what could be known as revenge funding. So that would be, some might say that the Hulk Hogan litigation funded by Peter Thiel would be an example of that. So there's a spectrum. Some we've seen for quite a while, and some are more recent.
Thanks, Emma. So I think, the foundational question here today is, why does it matter? And why is the topic becoming more relevant now? Well, for one, and as you can kind of see on the map here on the slides, states are increasingly taking regulatory action regarding litigation funding. In just the last year, the number of states that have statutes regarding disclosure of litigation funding has more than doubled. And because of the attention that litigation funding is receiving both at the state and federal level, we expect that more states will be passing similar statutes in the future. There have also been recent calls for federal legislation or uniform rule regarding litigation funding. So in June of this year, the House Judiciary Committee held a hearing on the impact of litigation funding by both third-party investors and foreign entities. And this included a statement from the U.S. Chamber of Commerce's Institute for Legal Reform, which has been pushing for years for legislation or changes to the federal rules for disclosure of litigation funding. And at the hearing, there were concerns raised by members of Congress, specifically regarding the potential of foreign influence, such as sovereign wealth funds from other countries being used to strategically promote foreign agendas through U.S. courts. The committee eventually sent a letter to Justice Roberts requesting that the Judicial Conference review the role of third-party litigation funding, the role it plays in litigation, and work towards enforcing transparency. So right now, there's no uniform rules in place. So there's a confusing patchwork of statutes, case law, local rules, and judicial practices and procedures regarding disclosure of litigation funding. For example, the District of New Jersey has a local rule, Rule 7.1.1, that requires disclosure of the identity of a litigation funder, whether approval from that funder is required for litigation settlement decisions, and a brief description of the funder's financial interest in the litigation. And Chief Judge Connolly of the District of Delaware has a standing order that requires similar disclosures. Other judges have tried to obtain details regarding litigation funding through ex parte communications, reviewing funding agreements in camera, or through other procedures. But there's no uniform rules, and you're going to face different considerations between jurisdictions and even between different judges in the same jurisdiction. And I think finally, the growth of litigation funding, as Glenn expressed at the beginning, means that there's many more opportunities for third-party funding in new and potentially controversial contexts, which has raised the possibility of greater scrutiny of all litigation funding. So we now see examples of companies directly financing third parties in litigation against their competitors, revenge funding by wealthy individuals to further personal motives. We have cause funding to achieve policy objectives, promote political candidates, or attack political opponents. We've even seen combinations of some of these all at once. If you recall the recent Gina Carano lawsuit against Disney, which was funded by Elon Musk through his ex-defense fund. And then we also now see some indication of foreign investment, such as sovereign wealth funds, to achieve strategic geopolitical objectives. And because of this enormous expansion will likely see additional scrutiny both at the state and federal levels.
I think we're on to the next slide. If we could go back one. Perfect. Thanks, Glenn. So to reiterate the point that there is massive change with respect to litigation funding occurring right now in the United States, it's worth underscoring that when you see a proliferation of litigation funding, you also start to see growth with respect to regulation. And in terms of the current legal developments that we are seeing in the US, there are, as of July of this year, 7 states that are regulating litigation funding, and there are different flavors for what that regulation looks like. But currently, Indiana, Kansas, Louisiana, Montana, Oklahoma, West Virginia, and Wisconsin allow for some regulation of litigation funding in their jurisdictions. The key is that the terms can differ and vary depending on what flavor of regulation has been adopted in a particular jurisdiction. Sometimes the courts in a particular jurisdiction are requiring that the agreement or the terms of the agreement be disclosed. In other instances, certain jurisdictions are requiring that the facts pertaining to the scope and the status of the funding and the nuts and bolts of the funding relationship be allowable in discovery. And that sort of discoverable information is all fair game in a particular matter. And then in other jurisdictions, we found that a party is required to disclose just how much influence a litigation funder has over the matter and the matter management, including with respect to making final adjudication decisions on whether or not the case will get settled, whether it will go to trial, and also approval rights on the settlement. The bottom bar there notes that there are sometimes restrictions in particular jurisdictions on funder influence. And Casey talked a little bit about the various ways that we are seeing new influence amongst the different varieties of third-party litigation. But the key here is that there are some states that are restricting that influence or status and limiting how much leadership and role a litigation funder can have over a particular claim. Montana, in particular, restricts the ability of a litigation funder to provide litigation advice or make determinations for the claimant on whether to file or whether to resolve a matter. And in West Virginia, Louisiana, and Indiana, there are particular limitations on the filing of a matter and a litigation funder's ability to have prosecution authority. If you could go to the next slide. Some of you that are in the audience might be very familiar with the Lawyers for Civil Justice. And Lawyers for Civil Justice is a coalition of corporations, law firms, and defense lawyers who all have a common goal of trying to promote fairness, predictability, and efficiency in the U.S. justice system, as well as reduce the costs of litigation and litigation burdens. LCJ is a fantastic organization, and one of the things that it does is works very closely to advocate for reforming the federal rules if and when those rules need to evolve or need a second look. And just 3 weeks ago, on September 3rd of this year, LCJ submitted a suggestion reiterating that the Advisory Committee on Civil Rules, as well as the third-party litigation funding subcommittee that was formed about a year ago, draft a rule that requires disclosure of third-party litigation funder contracts. And I'll read what's in the blue bar, but it's up on the screen now. The submission specifically noted that disclosure to courts and parties is necessary to inform case management and prevent misunderstandings caused by the control mechanisms in third-party litigation funder contracts that can alter the usual dynamics of litigation and resolution. A uniform disclosure rule would also relieve courts of having to expend judicial resources to decipher on an ad hoc basis whether a particular agreement should be disclosed in a particular case. And this language and this recommendation is similar to what happened several years ago in the insurance disclosure context, when there was a similar requirement and a change in Rule 26A that required that insurance coverage be disclosed in litigation, similar to the rationale of what the Lawyers for Civil Justice submitted to the Rules Committee here. In that insurance context, the rationale was that just like knowing insurance coverage exists, knowing that third-party litigation funding contracts are in the background of a matter and are part of the strategy of how a matter is going to be considered and led by a claimant will enable counsels to make better appraisals of the case and will allow for more informed strategy and matter management rather than letting cases be more blindly adjudicated based on speculation on who is funding what and who has an interest in the outcome of the litigation. So the next piece that we're going to look at are the actual submissions and some of the contracts that were part of the submission from LCJ. The LCJ specifically put some exemplar contracts into the submission to the Rules Committee, specifically addressing some of the contracts that are common or that are being seen time and time again, and that inform the impact of how third-party litigation funding can change a matter. So I'll turn it over to you, Emma.
Thanks, Erika. Yep. So LCJ's submission really dug into what these contracts actually look like. And starting with basically these provisions that give express control over decisions in the litigation. So the ILP funding agreement, it expressly provides that the lawyers and ILP will determine what claims should be pursued. It provides that ILP will give day-to-day instructions to the lawyers on all matters concerning the claims and that those will be binding. It requires the plaintiffs to instruct the lawyers to comply with ILP's instructions. And it also provides discretion for the funder to cease funding the claim, in which case counsel is required to discontinue prosecuting the claim. It also has discretion over appeals. The Therium Chevron funding agreement permits lawyers to do only 3 things without Therium's consent. You can join a party, you can add a new cause of action, and you can commence additional proceedings. Other than that, you have to prosecute the proceedings in accordance with the project plan, and any variation from that has to be approved by Therium. The Burford-Cisco agreement provides that in the event of a breach by the funded plaintiff, the funder may take over the conduct and the settlement of the litigation, including by instructing or replacing counsel, and provides that the funder will act in the name of the plaintiff. And critically, it requires the plaintiff to continue to appear at any hearings at the direction of the funder. So these are really giving the funders quite a bit of control in how the litigation is prosecuted. And LCJ argues that disclosing these types of provisions is necessary because knowing about these sorts of agreements allows the court to anticipate and avoid practical case management problems. For example, if a court knows that a non-party funder has significant control over litigation decisions, it may require the funder to appear to attend status conferences in addition to the plaintiff, because the plaintiff being there might not necessarily mean much if the funder is sort of in control in the end. And similarly, they point out that if a court is imposing costs or sanctions for discovery violations, it's important for the court to know that it may be the funder who was responsible for those decisions and for the sanctionable conduct. And so it's important for the court to know so that those sanctions aren't borne by the plaintiff when in fact the plaintiff may have lacked authority to prevent the conduct that the court has said is a violation. We can go to the next slide. Oh, Control over settlement. Perfect, thank you. So another main form of control that LCJ points out is control over settlement. So in the ILP agreement, it provides that the plaintiff is prohibited from having any communication with any defendant or defense representative without looping the funder in and having the funder's consent. So this would include settlement communications. And in the event of a disagreement, counsel will decide, and counsel is taking direction from the funder. With the Burford-Cisco agreement, it provides that the named party shall not accept a settlement offer without the funder's prior written consent. And there is a unreasonable, the funder can't unreasonably withhold the consent, so that's a little bit of a safety valve for the plaintiff there. With the LMFS funding agreement, the plaintiff gives the funder full and complete control, full and complete authorization to negotiate and accept any settlements, and agrees to cooperate and consent to any settlement deemed reasonable by the funder. And it requires the plaintiff to direct his or her attorney to settle claims as directed by the funder, and requires the funder's consent to dispose of or discontinue the claims. So again, LCJ is pointing out that the courts should know this because courts typically require that the decision makers are, if not in the room for settlement talks, at least available during a settlement conference. And so if a court's not aware that, it's ultimately a funder who may not be in the room who's controlling these decisions, that's going to interfere with the success and the efficiency of settlement conferences. Also, courts may not be aware that a funder's involvement may be a reason for delay in settlement if the funder needs time to review and evaluate every offer. That's obviously going to extend the process a bit. So LCJ argues that these are important provisions for the court to be aware of. Finally, LCJ points out that provisions like this can lead to what they call zombie litigation, where a plaintiff could be required to continue litigating even when they want to settle. So the LMFS agreement specifically requires that the plaintiff direct his attorney to continue proceedings if the company does not, if the funder wants to continue. And so LCJ again says this is important for courts to be aware of because they might not know why, the plaintiff's not settling. And they also point out that opposing parties should be more informed because it could guide them as to whether to make earlier settlement offers or to understand that settlement might be futile, even if they think it might make sense for the plaintiff. If there's a funder involved who's not going to be willing to settle, they might want to go ahead and prepare for trial right away. So LCJ again is advocating for both the court and opposing parties to be aware of these because of the effects that they can have on settlement. And I will hand it off to Casey for the next slide.
Thanks, Emma. And so in the same vein, there's some other provisions in these agreements that LCJ calls out. The first being provisions that obligate or at least incentivize plaintiffs to monetize equitable relief. For example, in the Litchfield Ventures agreement, if the funded litigant accepts a settlement offer that includes non-cash consideration, the litigant has an obligation to move the court to monetize that relief. And in the Therium Dominion funding agreement, if the plaintiff receives any sort of recovery in non-monetary form, then it must pay the funder the market value of those recoveries as established by an independent expert, also whose fees the plaintiff must pay. And so obviously these sort of provisions may change the funded party's incentives in litigation and especially in settlement negotiations because they may make equitable remedies that seem reasonable to the opposing party either worthless to the funded party or even a burden. We'll move to the next slide. So another type of provision that LCJ has pointed out in these funding agreements is the right to discontinue funding. Although a lot of these agreements will have boilerplate language that will say something like that the plaintiff has, full control of the litigation and the funder doesn't control the litigation behind the scenes, there are these provisions that give the funder almost unlimited rights to discontinue funding. And at least LCJ argues that those sort of provisions are important and the court should know about them, because even if there's boilerplate language that disclaims control by the funder, the right to discontinue funding may effectively give the funder control over the litigation, because the funded party is not going to want to do anything that will jeopardize the potential of funding. And similarly, the provisions giving access to confidential documents to the funder. So some of these agreements will have provisions such as the Longford Agreement, which has requirements of regular and timely disclosure of important documents to the funder. And this may include even deposition transcripts, discovery materials, key documents related to any material event or change in the prosecution of the claims. And where an agreement has these sort of provisions, there is a potential for it to run afoul of protective orders, or for the funded party to kind of be put in a position of either giving documents pursuant to the funding contract to the funder and potentially violating a protective order, or potentially violating that funding agreement and giving the funder reason to pull funding. Recently, there was a case, Valjarka versus Netflix, in the Northern District of California in July, where the court imposed sanctions under Rule 37 against a lawyer who violated the protective order by sharing confidential information of the defendant with a litigation funder, which included expert reports, information about source code, and financial data. The lawyer argued that the litigation funder was just a litigation services provider under the protective agreement, but the court didn't buy that argument, and sanctioned the plaintiff for that disclosure. So LCJ argues that courts should be aware of those provisions as well in fashioning appropriate protective orders, and that those provisions also raise concern about the court's ability to make rulings about costs and sanctions when the sanctionable conduct, as in the Valjarka case, may have been committed by the attorney or the plaintiff in the case, but in the background directed by the funder, even though that the plaintiff or the attorney might bear the consequences of the protective order violation. So I think that brings us now to recent case law.
Thanks, Casey. So stepping back to the current landscape, if you're in a jurisdiction where there isn't a specific state law or a specific court order governing disclosure of third-party funding agreements, it's basically a case-by-case basis through discovery motion practice of whether a court's going to order disclosure. And we found in our survey of the case law that courts are pretty limited in ordering disclosure of these. A lot of times you have discovery requests seeking disclosure, and the courts have required, a pretty particular showing of relevance. So some cases where it has been ordered, Nelson versus Millennial Labs, the court-ordered production of the plaintiff's fee agreement where the defendant asserted that a market competitor was funding plaintiff's litigation. And in Nunes versus Liza, the court found that litigation funding documents were relevant to respond to a David versus Goliath narrative, where the plaintiffs had not denied that the litigation is being funded by others. So in that case, you had the plaintiffs sort of trying to go for a deep pockets kind of David versus Goliath narrative, and the defendant said, hey, wait a minute, they have deep pockets on their side as well, and we should be allowed to get access to that and to present that to the fact finder. In contrast, in VHT versus Zillow Group in Western District of Washington, the court rejected a motion to compel discovery responses on the identity of the litigation funder, where there was, sort of kiss of death, nothing more than speculation in support of defendants' requests. So courts have required, some showing of relevance here in order to order disclosure where there's not a state law or another order in place.
Oh, can we go back to
Sorry,
the
I think we'll
prior
stay on
slide?
that slide in
Sorry.
case he's going to take over. Thank you.
Right. So we also see cases that apply the work product doctrine, even after determining that these discovery requests for both the agreements, the funding agreements, and then documents related to the agreements, including due diligence type documents, are relevant. Courts sometimes will apply the work product doctrine to prevent disclosure of these sort of documents. And again, it varies very much by the court. I don't know if there are any trends over time, but we do see that at least in patent litigation, the courts seem to be slightly more in favor of production of these sort of documents because they feel that they're slightly more relevant to claims because they relate in some way to the potential value of the patents at issue. So as some examples here, we have the Continental Circuits case from the District of Arizona in 2020. It's a patent dispute regarding manufactured circuit boards, and defendants moved to compel discovery of 3 types of documents: any final litigation funding agreements between the plaintiff and litigation funders, the identity of all the persons or entities with a monetary interest in the outcome of the litigation, and then the identity of the funders who were approached by the plaintiffs but then declined to provide financing. And the court essentially found that third category was irrelevant and was not going to be produced, but did find the first 2 categories relevant. That's the final litigation funding agreements and then the identity of essentially the litigation funders. But said that those agreements did not need to be produced, the agreements themselves, because they were protected work product. And in so doing was referring to the Ninth Circuit broad work product standard that a document is work product if it's created because of litigation. So the court said the only thing that you need to disclose in response to discovery are the identity of the funders, not the underlying agreements. We see similar things happening in the Fisher case. This is a key TAM case where defendants wanted all the documents related to the third-party funding agreements. The court said even though the realtors have to respond to the interrogatories and provide the identity of third-party funders, the agreements and the communications associated with those agreements are at least initially protected work product, although the court did require the realtors to provide a more detailed privilege log so the court could make more specific determinations about those sort of documents. And then you have the Devon case. That's an earlier case. In that case, the defendant did not ask for discovery from the plaintiffs, but went directly to a third-party subpoena to Burford Capital and its affiliates, seeking all the communications between Burford and the plaintiff, documents received by Burford about the plaintiff's activities, the plaintiff's business, due diligence type documents, and documents related to any sort of potential actual financing by Burford. The court granted Burford's motion to quash, found that all those documents were protected by the work product doctrine. However, we do also see some cases where courts are at least slightly more inclined to investigate further and potentially allow disclosure of some types of documents in discovery. So in the Impact Engine versus Google case, that's a Southern District of California case from 2020, Google seeks all sorts of documents related to contracts and agreements between plaintiffs and any funder, and any sort of communications between the plaintiff and the third party about the patents at issue. Plaintiff refuses to produce any potential or actual funding agreements, saying they're not relevant. And the court says that Instead, both potential and actual litigation funding agreements may be relevant to the case, both to establish the value of the patents at issue, obtain statements made by the plaintiffs about the patents at issue, and to refute potential trial themes such as the David and Goliath themes. But the court didn't rule on the work product doctrine and said that wasn't before it, at least in the current procedural posture. And then you have the Miller case as well. This is a Northern District of Illinois case from 2014 that is an incredibly detailed investigation of potential work product and attorney-client privilege in relation to litigation funding. And so in there, the court eventually allowed work product to be waived as to very particular documents. And in particular, it was damage summaries, damage estimates, and then related spreadsheets. When those sort of documents were shared with prospective litigation funders. But the court did not go very far beyond that and allowed both attorney-client privilege, common interest privilege, and work product privilege to be asserted as the vast majority of the documents that defendant wanted. So I think in general, we see, although there's some indication that courts are willing to allow some sorts of litigation funding documents to be disclosed in discovery, courts have been applying the work product doctrine to prevent the disclosure of the vast majority of those documents.
So another question that has arisen in this context is whether the use of a third-party funder deprives a plaintiff of standing to recover fees from a defendant under fee shifting provisions. And there's not a whole lot of case law out there on this, but so far it seems like courts have said no, it doesn't. So in the Fast Ship case, which is a Federal Circuit patent infringement case, the court said that the presence of a third-party litigation funder did not deprive plaintiff of standing to recover attorney fees. And in the NorCal Tea Party case, which was in the Southern District of Ohio, the court granted plaintiff's motion for fees in an action against the IRS, which was litigating the screening criteria of requests for 501c status. And the court said there's an important societal interest in rewarding attorneys and third-party funders who engage in public interest litigation. So in those cases, the court said, plaintiff still has standing, but you might still see defendants or opposing parties arguing that plaintiffs with third-party financial backing should not be permitted to recover fees, as that would constitute an impermissible double recovery. And you also might see, I think the Tea Party case, which was sort of a more of a public interest type case, was probably not a great case to challenge this, but you might see cases where a party is able to say that, allowing recovery here would be undermining the original purpose of fee shifting because they already have funding. So you could see that argument still arise, but so far we haven't found any cases where it was successful. And I think for the next section on ethical considerations, we're going to hand it off to Erika.
Thank you, Emma. So unsurprisingly, there are implications with both the model rules, which govern ethical conduct, as well as other professional rules. And we wanted to touch upon a few just for education and consideration. Some of the applicable ABA model rules are Model Rule 1.8F, and to refresh the audience's recollection on what 1.F speaks to, 1.8F essentially deals with the fact that clients need to be paying for client work. And the rule specifically states that it prohibits compensation for representing a client from anyone other than the client, unless the client gives informed consent. In other words, the client gives informed consent that outside compensation can be made by a third party. It also prohibits compensation, and as long as if there is no interference, it is prohibited unless there is no interference with the professional judgment or the independence that pertains to the attorney-client relationship. And it prohibits compensation if the information related to the representation is protected as required by the attorney-client privilege. Model Rule 5.4a specifically prohibits fee sharing, and any fee sharing with a non-lawyer, except in very specific limited situations. And Model Rule 5.4c deals with the fact that a lawyer should not permit a person who recommends, employs, or pays the lawyer to direct or interfere with a lawyer's professional judgment in rendering any legal services. So those are the applicable model rules. And then the ABA best practices for third-party litigation funding is additional guidance that everyone should be aware of. The American Bar Association House of Delegates issued these best practices for third-party litigation funding specifically to be non-binding guidance, and to focus on lawyer-funder interactions in a matter, as well as what constitutes or should be limited with respect to third-party litigation funding control over a matter. This is, again, it's guidance. It's not an obligation. They're just shorthand best practices for key considerations. But if anyone has not familiarized yourself with these best practices, it's a 22-page document that speaks to a whole host of different third-party litigation funding scenarios and categories of litigation, including class actions, international arbitrations, and a host of other types of litigation. And again, it's not meant to be read as any sort of recommended standard for professional conduct, just guidance, but it emphasizes the fact that there need to be clear terms on disclosure, and that there should be agreements that any litigation funding be required to be non-recourse, which means that there can't be any personal liability. The repayment is solely dependent on the outcome of the litigation. And one of the other major highlights of this guidance is that it prohibits funders from influencing the strategic litigation decisions in a matter. And Casey also mentioned earlier the fact that the revenge funding concept is one that a number of parties and cases are talking about and thinking through. The guidance, or the report as it's called, also addresses this concept of revenge funding and counsels that parties should proceed with caution, because a funder shouldn't have personal objectives for why funding is being provided for a particular matter, and you really need to focus on the motives of why the funding is there and whether it will have any implications on both the enforceability and the legality of a matter and the adjudication of a matter. So not surprisingly, not everyone has agreed with some of the guidance that's included in this best practices report that was issued in 2020. And again, you will not have to search far to find some of the available criticism of the report, but just to, again, underscore some of the highlights. Some say that you can't really call commercial and consumer litigation an apples to apples comparison that would include or involve the same guidance or rubric. You can't have a single standard, and you need to think through the various complexities and needs of the different types of litigation. Others have criticized the guidance as being too confusing and not really reflecting some of the aspects of how the commercial funding by third-party litigators or third-party litigation funders work. And then lastly, one of the other key criticisms is that the report is, in some people's view, overly cautious on what constitutes protected attorney-client communications and work product. So those are some of the ethical and professional considerations as some of the key highlights on the best practices for consideration when it comes to third-party litigation funding. Casey, I'm going to turn it back over to you to talk about some of the practical implications now.
Thanks, Erika. So what are the practical implications? Well, I think first is, if you're a litigation funder evaluating cases, or if you're a plaintiff looking for litigation funding, you should consider whether the case is a good candidate. And that involves considering both the relevant disclosure statutes, the rules, the standards that you'll likely face. So for example, if you're in state court, is there a state statute that regulates disclosure of litigation funding agreements? If not, are there decisions from the state court suggesting the court's amenable to disclosure? If you're in federal court, is there a local rule governing disclosure? What about standing orders from district court judges? Do these only require disclosure of the basics of the funding agreement, the identity of the funder, or do they potentially allow discovery of the agreement itself upon request of the opposing party, or even discovery of potential funding agreements that didn't come to fruition? And then you'll have to look at how courts in the jurisdiction have ruled on disclosure through discovery. It's also good to think about, as what Erika was talking about, the state-specific ethical or professional rules that may apply to this, whether they mirror the ABA's model rules or whether they go beyond that. And that kind of goes hand in hand with some considerations about the strategic value of both disclosure or non-disclosure. So for instance, if disclosure of the financing arrangement itself is required, will the case be impacted, and how will the case be impacted? For example, if you're a plaintiff in a class action and you're pursuing kind of a David and Goliath narrative, you're portraying yourself as kind of the everyman fighting against the deep pockets of the corporate defendant. Will this strategy be implicated if the other side obtains disclosure of the litigation funding arrangement? What happens if you're a plaintiff that happens to be funded by the corporate defendant's competitor? And what about procedural considerations? So if the litigation funding agreement doesn't provide the plaintiff with any sort of settlement authority without input from the funder, will the court deal with case deadlines, missteps differently than if the court thinks it's an actual pro se plaintiff? Generally courts give pro se plaintiffs a lot more leeway than they might give to a plaintiff who has a large litigation funder behind them. And then what about settlement? Will the mediator that's selected view the balance of power differently when there's a litigation funding agreement in place? Another consideration is regarding the risks, is what might be disclosed. Will it just be the agreement or potentially documents, due diligence type documents exchanged between the party and the litigation funder about the strength of the case, about key facts in the case? Are those documents likely to be protected under work product in this jurisdiction or common interest, or is this the sort of case or jurisdiction where they might not be protected? And then what documents exist around those considerations, and what do they say? Are they very candid in their assessment of weaknesses of the case? Are they actually positive in the case that you may want those documents disclosed to the other side that show how strong you think the case is? And could those documents ultimately disclose information that might even be damaging to the requesting party, which might not otherwise come out through discovery? And so those are all sorts of things that I think are up in the air at this point, and I think that are interesting considerations that both funders and potential funded parties should think about when determining whether a case is a good candidate for funding. So I'll turn it back to Erika and Emma now to kind of conclude here.
Thanks, Casey. So just to conclude with some of the high-level takeaways and things to keep in mind and continue to consider as you are evaluating how third-party litigation funding might apply to you and your legal realm. Number one, more states are getting involved in making decisions on what, when, and where third-party litigation funding can be present. And we expect that we're going to see more states getting involved in passing very specific statutes to address the implications and the contours of third-party litigation fundings. As we talked about earlier, expect some of those flavors to be requirements that the actual third-party litigation funding agreement be provided. Some of those exemplars that Emma talked through are absolutely going to be documents that need to be exchanged between the parties in some jurisdictions. That already is the case, and we expect we will see more of that. We also expect that some jurisdictions will require discovery or allow discovery on what is occurring with third-party litigation funding so that the implications of that funding can be explored in discovery and be known by all of the parties. And then also more of the impact of how third-party litigation funders can and cannot influence litigation. We talked through some of those examples when we were talking through the case law, and we expect more states will get involved in regulating that ability to influence the matter and take the reins over the litigation throughout the life cycle of a matter.
We also think we'll see case law continuing to evolve on the work product and common interest front. We saw the tension between the ABA's sort of cautious recommendations and then the actual case law, where it seems like courts are pretty protective of these. But if you think about it from a lawyer's perspective, you might have a lot of great cases to cite in that motion practice, but if the documents are so sensitive, like Casey was talking about, where it's going to be basically a very frank, candid assessment of maybe some weaknesses in your case, are you going to be comfortable, that a judge in discovery motion practice isn't going to go the other way? And another thing I would note on this front is I think the LCJ submission itself could be influential in terms of judges now having seen some of these provisions. They may be more sympathetic to discovery requests and a little more skeptical of protecting these agreements. So we could see that submission itself having an effect on how courts view these.
Absolutely. And then finally, we started with Mark giving the staggering numbers on how there has been a big spike in the growth of commercial financing, the current the current amount that we're seeing in 2025, and I'm sure it's growing even as we're sitting in this webinar, is just under $20 billion. And we expect in the next 12 years that number will grow substantially and will be just under 70 billion in third-party litigation funding in litigation matters across the country. So given that growth to be continued on exactly what happens with courts and with the case law, but it's probably a fair prediction that at least some courts are going to become more involved and more skeptical on exactly what to do with the roles and responsibilities of third-party litigation funders and want to have a hand in making sure they understand the implications of third-party litigation funding and how that might control matters on their docket. So with that, I think I turn it back to you, Mark.
Thank you very much. We've had one question in the comments, and that is that you all have done an excellent presentation. So thank you for the thoughtfulness and the obviously the time you spent putting into this. It was substantial, and a lot of the slides at the beginning focused on elements in the agreements that suggest a level of control or potential control by the funders. And I was wondering if you could comment on how that may be in tension with lawyers' ethical duties.
Sure. Who wants to take that? I can take it. I want to make sure I understand the question. Was it in the chat or?
I read a chat and then I put in my own words. So the question then is, so you have these provisions in the agreements that suggest some possibility of control, and is that do you see a tension there between lawyers' ethical duties?
Well, I think yes. So just to go back to some of those model rules that we talked about earlier, there's an ethical duty. If you were an attorney and you're responsible for a matter, you are in a direct relationship with your client, and you have duties like the duty of protecting client communications, the duty of thinking through your fiduciary obligations to your client. And just to be really simple, when you add a third-party litigation funder or a third party to that relationship, there are implications, including on the model rules that we talked about, because when you add that layer, you've got someone else that is involved in the relationship that can be making decisions that might actually interfere with the direct relationship between the attorney and the client. And they might have a different perspective or viewpoint or concern that is more focused on the monetary outcome rather than other issues that can implicate why a client might be interested in the ultimate outcome of a matter. So there could just be additional conflicts of interest that I think require some due diligence by the attorney responsible for safeguarding that attorney-client relationship. And if we're talking specifically about the model rules that are implicated, I think I'm just trying to find the ones that I referred to earlier. I think specifically it would be 18 that we would need to be focused on, because with respect to that, or I'm sorry, 1.8, there are real responsibilities in safeguarding the payment of who is paying the attorney for the work. And given the fact that it really needs to be the client, when you have a third-party litigation funder who has a dog in the proverbial fight, it can sort of change who's controlling. When you have a change of who's controlling the purse strings, you can have a change in terms of who is controlling the ultimate strategic drive of the matter. So that's something that I think needs to be front of mind to attorneys when thinking through the implications of bringing a third-party litigation funder into the framework of a matter.
Thank you. The other thing you noted in the slides that there's a lot of variation between how states or courts are dealing with disclosure. Some states have mandatory disclosure of the agreement, very robust provisions like West Virginia, Montana, Wisconsin, Georgia, but others are providing for in-camera inspection by the court only. And I was wondering if you can comment whether, in your opinion, that suffices to address the issues that you've talked about.
Yeah, so I think LCJ kind of gets into this in their submission about, they're suggesting moving away from sort of handling these on an ex parte basis. And they have a couple of arguments. One is it's a strain on judicial resources. Courts are busy, judges don't have a lot of time to sort of wade through these complex contracts. And then there's a transparency argument as well, where I think they argue that letting these sort of get worked out in the adversarial system where, I would imagine that, you're going to have opposing counsel sort of trotting out this parade of horribles about, all these scary provisions in the agreement. And then you'll have the third party funded side saying, no, these are all okay, and here's why. And then you can have the judge sort of sift through those. And so I think the argument is it's more transparent and it's more efficient. And then also they argue that, I think having this sort of transparent disclosure through the adversarial system will have sort of a feedback loop where if these parties entering these agreements are aware that they're likely to be disclosed, they're going to be more cognizant of how these provisions might look, and they might be a little more cautious in providing a lot of control to the third party funder. So those are some of the arguments that they make in terms of the transparency and the efficiency of having a more formal, transparent process as opposed to the current ex parte case by case situation.
We have a couple of minutes. I have one other question, and then we can see if anything else comes in from the audience. That really goes because your firm has substantial expertise in handling discovery matters. And in 2015, Lawyers for Civil Justice was very involved, as you know, in having changes made to the federal rules that govern discovery. And one of those deals with cost shifting through protective orders. There's now express authorization for courts to engage in cost shifting in discovery. And I'm wondering if you could comment on the implications of third-party funding in that. That it would seem to me that if courts become aware that cases are no longer involving, let's say, the impecunious plaintiff against, a multinational corporation, that they might be open more towards cost-shifting arguments by defendants if disclosure is available.
So I can take that one too.
Okay.
The short answer is yes. I think you're exactly right, Mark. I think that cost shifting is going to absolutely be at play when the parties who are responsible for the costs are shifting. So when you have a third party litigation funder who, again, is involved and is providing the purse, so to speak, for how the litigation costs are going to be handled, cost shifting needs to be considered because it does have implications, even under the current rubric of the federal rules, on how you're thinking about cost and burden of cost for the parties involved in the matter.
And we're coming on our 3 o'clock hour, but one final question. So I know when litigation funding started, it was really focused on individual lawsuits. But as we've seen the growth of the industry and literally tens of billions of dollars coming in, is that where it is today? Or can you comment, where is most of the money being deployed today that comes in through funding?
Well, I can talk about this quickly, and then anyone else that wants to speak, Casey, Emma, feel free to jump in. I don't think it's as one note anymore, Mark. I think what we are seeing with respect to the new influx of money, of funding that's going into third-party litigation funding, is that it no longer is single plaintiff. Casey talked a bit about the Peter Thiel, Hulk Hogan litigation, where we started to see this concept of revenge funding sort of rear its head. And yes, that was a single plaintiff matter, but I think it started to show how there were new flavors in terms of why organizations are getting involved in the third-party litigation fight. Not just the funders themselves, but even corporations are deciding to put money behind certain matters because they might have an interest in the ultimate outcome of litigation, because the ultimate outcome of litigation might in some ways change the case law and change the framework for how different matters may be decided. So now and over time, I think we're going to see a major evolution in terms of what types of matters, and this is also specifically occurring in the class action space, what types of matters are receiving funding by those third-party litigation funders. And it's much more diverse than it was when third-party litigation funding started.
And final question, and then I'll send it back to Glenn. I now live in South Florida, and you can't turn on TV without seeing a legal services ad of some sort, either law firm ads or lead generator firm ads. There's really just been an explosion in legal services advertising. And I wonder if you see a connection there with third-party litigation funding. Are you seeing evidence that maybe the funders have moved beyond just funding litigation and are actively working to create it?
So I can again take this one, but other people should jump in. I don't want to dominate the time. I think yes, but I also think that there are a number of different plaintiffs firms that are self-funded now, that are able to sort of bring the bag of money to help deal with the funding on their own independent basis. However, and again, not to keep underscoring class actions, but I think with respect to class action work, in jurisdictions where there has been a requirement that third-party litigation funding be disclosed, we are seeing a real uptick in where third-party litigation funders are helping with the funding of the matter to give the matter more life, longevity, and more heft. So yes, I think that it has sort of changed the equation for the plaintiff's bar in terms of how to fund cases and move forward with litigation.
Thank you. Glenn, we're on the hour, so let me kick it over to you.
Well, thanks very much, Mark, for your yeoman's work on the program, and for our three panelists for putting together such a well-organized and extremely informative discussion for us today. I failed to mention at the outset that our three panelists today also wrote a paper for WLF that we published last month by the same name as the title of this program. So if you're interested in reading that, that's available on our website, again, at WLF.org. Thank you again for joining us, and for our panelists as well. When everyone signs off, if you would take a minute or so to do a survey that will auto-launch, we really appreciate it. Again, thanks for joining us.
Thanks for having us.